All right, shall we continue? I want to talk about this case, MacRobertson and the Commissioner of State Taxation. Okay, this is a 1975 case, so it's not hugely old. High Court of Australia, you can find it in your textbook. Okay, sorry, I'll just... Basically, I'll go through the facts first, but I want you, as I'm just doing a high-level view of the facts, to think about why do we care whether this is a contract or not? Why does it matter? So basically, the way that this particular transaction works is that, so MacRobertson is basically an airline or travel agency. And the way that the transactions work is passengers would tell MacRobertson that they, or their travel agent, that they wanted to fly somewhere. The next thing that would happen is that MacRobertson would tell the passengers or the potential customers of what flights were available and how much they cost. The passenger would then say, well, I want to go on that particular flight at that particular price. They would get a ticket that MacRobertson would issue, and on the back of the ticket there was an exemption clause. So the clause itself basically said the airline may or may not fly based, essentially it was very broadly drawn exemption clause at their whim, let's say. And on the time that was stipulated on the ticket, the passenger would present the ticket to get on the flight. So the question here is there a contract? Short answer, yes, there is. But where and when was it formed? Who made the offer? Who accepted the offer? Actually, sorry, I said short answer, there was. I'm not sure about that. So think about this. Why does the Commissioner of State Taxation care when and where a contract is made? I'm hearing stamp duty murmur over here. Jack, do you have something?
If it's a flight and they're paying tax based on the tickets on what state, I guess.
Exactly. So it is stamp duty. So stamp duty is essentially a form of tax. It's a tax that can be levied by the state. If the contract's made in Western Australia, under Western Australian rules, stamp duty would be paid on the ticket. If it was made in a different place, the rules of that different place would apply, and if stamp duty applies, it would be paid in a different state. So stamp duty is just a form of tax. Literally, back in the day, it looked like a stamp. So these days, I sort of went through it being like a physical stamp as opposed to like a postage stamp. These days, you put a piece of paper through a machine and stamp duty is paid. Formalities often attached to stamp duty in some way because it's a way for tax collection. We need to have a document. The document will only be enforceable if stamp duty is paid on it, and so on and so on. So basically the High Court here had to determine whether a ticket was issued was an agreement or a memorandum of agreement, and if it was, then stamp duty would be payable. But maybe it was something else altogether. Now what's important in this case is the ticket contained a condition that gave the airline the right to cancel a flight or cancel a booking without incurring any liability at all. So let's have a look at the arguments. For a change, I've got them all on one slide, which I think makes a little bit. So MacRobertson said, by tendering the ticket, MacRobertson was making a written offer to the passenger. And then by retaining the ticket without objecting to it and paying the fare, the passenger accepted the offer by their conduct. So here, there's no contract because the airline's consideration is illusory. So this we also could have thought about this in consideration. Could have thought about it in certainty as well. So by illusory, it's saying that because there was effectively no real promise to carry the passenger, that the discretion was so broad that the airline could step out at any time. In fact, there's no contract. Because what are the elements of the contract? They offer an acceptance to form agreement. The if we don't have offer and acceptance, we need to find a meeting of the minds. We need consideration. I've talked about that a little bit in War and Mills now. Consideration is something more than price. It's evidence of the bargain or a quid pro quo. We need intention to enter into a legal relationship, and we need certainty. So they're saying, well, actually in this case, sure, we made an offer, you accept it by your conduct, but in fact, we haven't really made any kind of promise to carry you. It's an illusory promise because we can walk away from it at any time. The Commission, on the other hand, said that the offer and the acceptance in the case of a purchase of an airline is completely mixed up. So in fact, it's the consensus here at even that we're looking for. We're looking here for the meeting of a mind. The ticket is the agreement because it gives rise to an obligation to carry the passenger. Only when the ticket is issued that we have the final statement of what the agreement is. And the exemption clause on that ticket can absolve the airline from an obligation to carry, or it can frustrate the passenger's hopes, but it doesn't remove the agreement altogether. It doesn't negative the agreement. Shall we say, if any of you ever make it to the High Court, and I really hope you do, because I'd really like to go to a High Court admission ceremony. If you ask one of the other teachers now that we've mentioned, I would be heard. But anyway, could you just write a little bit more clearly than words like negative the agreement? Like, really? Anyway, but I think you can see what we mean. So what do you guys think? Had a chance to look at the game. Michael?
You've got a shoe lane parking issue.
We're jumping ahead here. Shoe lane parking, one of my favourites.
Yeah, because the airline has put a condition on you, if you like, on the back of a ticket after you've purchased it.
Yep. So this is the question. Is that extra condition, is that part of the agreement? So is it, well, so there's a whole heap of different ways we could look at it. I would actually think it's probably in that sense, probably more like Oceanic and Fay, if we're going to jump ahead a million cases. But the question there is, at what point is the contract made? And if you're adding in a new clause after the contract's made, can anybody be bound by it or held to it? So that's the issue that those kind of cases deal with. Shoe lane is more, the condition was there before he entered the parking lot, you couldn't see it. So, fine. But, at risk of going completely off piste. Here, goodness me, sorry. Just that.
But the example, it didn't negate the agreement.
No, what I'm saying is, where here is, if it was part of the promise, was it so broad that there's no consideration, that there wasn't really an offer that was capable of acceptance for the purpose of making a contract? So that's essentially what the question was in this context, is offer and acceptance, they're all really mixed up. But at the end of the day, this broad term, the Commission is saying, yeah, it's a broad term, but it doesn't actually mean there's no agreement. MacRobertson's are saying, well, actually the ticket is just really part of our administrative process. We make an offer to carry somebody, but it's subject to this condition, and you accept it or you don't. You accept it at the point that you take the contract.
They go a step further than that, and they say that it's not agreement until you actually present the ticket before getting on the plane.
Yeah. Well, ultimately we end up with the same answer here, but we get there 3 different ways. So this is actually new for me. I think I've, in the past, gone through all these different ways of doing it. I've decided to try and get it all on one slide. So, because this is a complex case to understand, particularly as it deals with this idea of an illusory consideration before we've talked about consideration. And it's also talking to a certain extent about this idea of certainty. But what I want you to extract from this now, but think about it again when we get to consideration. What I want you to think about now is for an offer to be capable of acceptance and end up making an agreement, that an offer itself needs to contain all of the things that we need for a binding contract. Acceptance is just the yes. Everything else has to be encapsulated in the offer. So what Chief Justice Barwick said is, actually the ticket itself isn't an agreement, it's the terms of an offer that's subsequently accepted by conduct. However, because the exclusion clause was so broad, Barwick said, actually it's not really capable of being a contract. There's no promise made, so there's no agreement. Justice Stephen, on the other hand, said, actually this is just a ticket case. We'll do lots of ticket cases. There's some about horses, which you'll enjoy. There's quite a lot of parking tickets that we will talk about, like as in parking station tickets. We'll talk about buying tickets on boats. We've got a number of disasters on cruise liners that we will, we go through these. So this is a ticket case. And so we're approaching it from the kind of approach that Michael took here is, at what point is the agreement made in order to work out what the clause is? And he said, well, actually, the ticket is an offer that was subsequently accepted by conduct. Adding this clause in too late, or after that, it makes it too broad. Justice Jacobs, on the other hand, said the ticket records the offer that the airline has made, and the offer can be accepted or rejected by the passenger when they've had time to read the conditions. So, 3 different sort of similar results got there in really, really different ways. Very difficult case to reconcile and very difficult to use as authority for something. If you are citing this case in support of an argument that you have or an observation that you're making in an assignment, you would probably need to identify which of the judgments you're talking about. Because we've got 3 judgments that come to the same conclusion in quite different ways. So the point for our purpose here, ultimately, in order to have agreement, if we're going down the offer and acceptance route, then the offer itself needs to contain all of the information that we might need in order to accept or create a contract. Yes, Jack?
Would any of the justices' reasoning have more weight than the others?
Do any of the justices have more weight than the others? Technically, no. But the fact that Barwick is the Chief Justice and Jacobs, a large part of his decision was in support of the Chief Justice's judgment, I think there is probably more weight in relation to the no promise, no agreement. And in that sense, Stevens and his statements about that being in, because essentially Jacobs is agreeing with that, but then saying, but you've got a chance to decide whether to accept it or not.